In other countries such as the USA and Canada, the Recording Industry Association of America has filed up to 20,000 lawsuits against individuals for copyright infringement.
A case that brought the issue of copyright infringement over the internet to the forefront was the famous A&M Records versus Napster.
This program allowed music fans to share files, bypassing traditional means of distribution and therefore affecting the revenue of the firms.
In spring 2000, Napster had roughly a few 100,000 users. By February 2001, over 15 million people were using the service.
This led to the Recording Industry Association of America suing the creators of Napster for allowing users to violate copyright law.
At which point Napster opted for an out-of-court settlement of $1 billion.
Illegal downloading has continued to grow. Despite the emergence of legal downloads as a viable alternative, which is now worth $5 billion worldwide, in 2008, 95% of all music downloads were still illegal. Here we have a fairly typical scene, a music fan accessing potentially unlimited quantities of music thanks to the birth and rapid growth of the internet.
Freeze! Paris is a crime!
However, what is even more typical is the way in which the music is being downloaded by Lucian illegally.
15 to 20 years ago, users could access music and other digital media via the internet.
The idea of accessing music across the internet has been around for some time. However, this was limited due to the networking technology in place at the time.
So the amount and quality of media available meant that the practice of accessing digital media through the internet was relatively small in scale.
But by 1999, the networking infrastructure had been vastly improved globally, and as a result, users were able to access digital media on a much larger scale.
In addition, this brought a new possibility along, the ability for users to bypass the authenticated distributors of digital music
and share freely between themselves, so-called peer-to-peer activity. Mr. Lucian, did you know that copyright law originated in the United Kingdom from a concept of common law, the Statute of Anne 1709? It became statutory with the passing of the Copyright Act 1911. The current act is the Copyright Designs and Patents Act 1988. Examples of the cases that have brought up the issues of internet copyright infringement, such as Bryan versus Techno Design Internet Programming BV 2006, Sony Music Entertainment UK versus Easy Internet Cafe 2003, and Coda versus Lauritsen 2001.
The British phonographic industry is, however, less aggressive in targeting downloaders than international counterparts. They prefer to target internet service providers and have their connection terminated. However, this has come under criticism due to possible violation of privacy. Having said this, the BPI has targeted users in an effort to deter others. One case of this type in the UK where 5 men accused of uploading close to 9,000 songs between them. They were ordered to pay £5,000 apiece after an appeal heard by the High Court failed. One of the defendants claimed ignorance for not understanding that what he was doing was illegal. This was dismissed by the judge.
Alright, Lucian. Under UK law, you have two choices. Since this is a civil law case, you can either decide to settle outside of court and pay a fine of £300 or more, or you can decide to defend yourself in front of a copyright tribunal. But this risks of incurring higher costs, because if you're found guilty, you'll have to be charged with the proceedings. If that is the case, if you are found guilty, the judge's decision might be referred to the higher court if you decide to appeal.